Like the parties are ready. We're now here for the case of Thorington versus Scott County. Mr. O'Brien, you may begin.
Thank you, Chief Justice. Justices, counsel, Dave O'Brien here, representing Patty Thorington. You may recall this is the second time we've been here, but we are here on summary judgment motion now, where the district judge granted the defendant's request for summary judgment, basically applying, not basically, in fact, what actually happened was he applied statutory emergency response immunity to an assault and battery case, and because the statutory immunity applied, he threw the case out. I thought the district court judge, a lot of times when I'm up here arguing about summary judgments on behalf of plaintiffs whose cases have been thrown out, we're arguing about the facts, but I didn't intend that to be the case because I think this is a purely legal argument. And I accepted the facts that the judge sent out. I think his intent was to make it a legal argument. He found that these statutory immunities applied. He certainly listened to our arguments. He kind of, said or indicated that he understood the arguments we were making, but unless and until the Supreme Court told him specifically that these statutes do not apply in assault and battery cases, he was going to follow the statute, and I can't really blame him for coming to that conclusion. So we came up here saying we're not really disputing facts. Well, as you'll note from my brief, I didn't dispute the facts the district court did, but unfortunately, in my view, I say unfortunately, the defendants decided to put a lot of additional facts in the record that are hotly disputed, and in fact, some of them are just inaccurate. And so to the extent that you are concerned about any factual issues that come up, I would ask you to look at our reply brief where we went through all of these facts and pointed out, that this was not a high-speed collision. This was not a major incident. The maximum speed.
More than once. You're saying this was not this was not like a stressful, scary situation?
I think it was an emergency situation as the judge found it, although I have a problem with what he found. What I'm saying is the maximum speed of the vehicle was 10.4 miles per hour. I don't think so. I mean...
Are you? I watched that video probably 20 times because there's like 6 different angles you can watch. And I mean, my heart was racing the first. I cannot. I mean, it all is over what, 15 seconds?
I included this in my brief. The National Highway Traffic Safety Administration doesn't even include injuries caused by vehicle collisions under 20 miles per hour. These are not dangerous situations. He was backing up and moving forward.
From NHTSA include guns being drawn, and I mean, would those cases all involve a weapon already having been out with law enforcement?
There's no allegation of any sort of weapon in this case other than defendant.
And I'm just wondering about the other cases you talked about. But my question is, it is factual in that, and to me, I'm having a hard time being persuaded that this isn't definitely an emergency situation. Help me get beyond that.
It's not an emergency situation that can be relied upon. One of them is that it's a relatively low speed, maximum speed. It's undisputed, 10.4 miles per hour. Backward and forward. But the second and really critical factor, Justice Christensen, is that the officer was in that situation because he simply refused to let go of Bobby Mitchell's hand.
Just to be clear, when officers are arresting folks in these circumstances, you think the rule they need to follow is just to let them go?
No. I think the rule they need to follow is don't create jeopardy for yourself.
What's the creation of this jeopardy? The genesis is your guy. It's not the cop.
He jumped in the car and tried to get away. He did not, under our rules of law, deserve to be executed for making that escape attempt. The only thing that put Deputy Hill in jeopardy at the time of this incident was his own refusal simply to just let go of Bobby Mitchell's hand and walk away from the car.
I mean, he's trying to stop this guy from fleeing.
All your questions are reasonable, and they all raise fact issues that should be decided by a jury on a justification defense.
O'Brien, here's, we've all watched the video, and it's really, it is really disturbing what happened. I acknowledge that. On the other hand, you did not bring a 1983 excessive force claim. So what we have is a state law tort claim, and all I can do is read the language of the statute. It says, claim based upon or arising out of an act or omission of a municipality in connection with an emergency response. And I have trouble getting past that language, that this was not an emergency response.
The statute doesn't even apply because we're not relying on exceptions to a statute where our waiver of sovereign immunity is not reliant upon the general waiver of sovereign immunity contained in the Municipal Tort Claims Act. So, I mean, it's just a common sense logic approach.
Question, how does Iowa Code Section 804.8 play into how we should read emergency response immunity under 671K, 674-1K?
Plays perfectly into the idea of whether this was an assault without justification or not, where fact issues are created for a jury to make that decision. 8048 sets out a standard that officers are required to follow when deciding to use deadly force. Deputy Hill did not follow those standards. Now, does that create a separate right, statutory right to file a claim under 8048? We argued before the district court that it did, and that may or may not be the case because it doesn't matter. We have an independent right, as you all have recognized in White versus Harkrider, to file a claim for assault and battery with the affirmative defense of justification being allowed. So all these issues that you're raising can be decided by a jury based upon that analysis.
That's what I'm asking. Does 804.8 influence how we should read 670.41K?
Absolutely does. I mean, the introductory language of 674.1 says that these exceptions apply if there's no other statute that is on point that provides something different. And 8048 clearly is on point for use of deadly force, and it clearly prescribes a course of conduct that Deputy Hill didn't follow. Now, you can argue about whether that means we have a private right of action, but we don't need it because we already have the common law claim for assault and battery. And in my view, these work perfectly well together because we can go and say, we want an instruction on 8048 as part of our justification defense. We want to argue that, and a jury can assess it. Did he follow the law? And we have a right to make the claim because it's an assault claim that was recognized going back to the time of the adoption of the Iowa Constitution in 1857.
On that point, both sides cited Socorro in a notice of additional authorities. Why did you cite Socorro?
I cited Socorro because I think it made pretty clear the difference between how local officers are going to be treated differently than state officers. And it's kind of like Thomas v. Gavin, Justice Mansfield, your decision going back predating Godfrey, right? I mean, it was clear that assault and battery claims, you said this in your case, assault and battery claims were not dependent upon the general waiver of sovereign immunity contained in the State Tort Claims Act.
Four of us have said in Socorro the legislature can modify the common law. Yes. And that's what they've done in this emergency response immunity, isn't it?
Judge, I'm sorry, Justice Mansfield, the exact opposite is true. The clear legislative intent. The Iowa State Tort Claims Act is passed in 1965, and it includes specific language that does not allow assault, battery, and wrongful imprisonment claims against state actors. 2 years later, in '67, they passed the Municipal Tort Claims Act, and they leave that language out. Now, what could possibly be better evidence of legislative intent?
Battery claim, but it's subject to this emergency response immunity, right?
I don't agree with that, Justice Mansfield, not if it's against state or against municipal actors. It's true, I understand the divide on the court in Socorro for state actors. You don't have the same divide here.
Why wouldn't it be the same rule for municipal actors? I mean, It's the same principle, that the legislature can modify the common law. And
You can walk across the street and ask them while they're treating municipal officers different than state officers. I don't know the answer to that, but I know that's what they did.
He's trying to ask a question.
no, all I'm saying is, I mean, do you have I mean, do you have any majority of opinion of our court, majority opinion of our court that says the legislature cannot modify a common law cause of action for damages?
I have your implicit rejection, which I think you're going to have to reverse if you want to, in White versus Harkrider, where you specifically said that it's an assault and battery claim, and the defendants argued for statutory immunities. That argument was ignored, and you sua sponte raised a justification as the affirmative defense to be applied.
That there's no disagreement among any of us on our court that under the Municipal Tort Claims Act, you can bring an assault and battery claim. The issue is, can the legislature narrow that claim by providing an emergency response immunity, right?
To ask you to think about the intent of what your argument points towards. That you are about to hand, theoretically, local police officers carte blanche to use deadly force against anyone. And
use that line of argument, Mr. O'Brien. I think you need to consider, why didn't you bring a 1983 claim? Why?
Because in federal court, if as a plaintiff's lawyer, you try to go to the court where you think you have a better chance of prevailing, you've seen that in the Mormon case. You see that in other cases where these issues are being raised.
So if I understand your argument, I know you have these fact disputes about the emergency and whether this was an emergency, but I think this is similar to the argument you made in Mormon, which is there are explicit statutes that provide and recognize liability for officer use of force, so 674 doesn't apply. It's kind of like the 321 recklessness statute. And is that what you're arguing, that we don't need to deal with these fact issues?
Yes, I mean, Deputy Hill had an obligation to comply with 8048, and he didn't do it. And then the question becomes, well, can we sue him for that? Well, maybe it gets a little more difficult if you want to bring a statutory claim directly, but we already have the assault and battery claim.
This is McDermott, I believe. You started talking about the first sentence of 670.41, and it does talk about liability extends to the only an officer can be liable to the extent liability may be imposed by the express statute dealing with such claims. And so is that your argument that 8048 is that specific claim, that specific statute that deals with the excessive use of, or use of deadly force?
Absolutely. 8048 is specifically
That's the one. Then what in 8048 then expressly allows for liability?
Again, my argument is I don't know that I need express liability. I just need him to have to follow the statute, and I can hold him accountable under an assault and battery claim. But you will find express language in 704, which also applies to police officers. And then in 704, 12 or 13, I think, it talks about them potentially, well, they have some immunity from civil liability. It talks about civil liability there. So I do think I can get there.
Is that basically the argument you were making when you were talking about private causes of action, or was that a little different?
That is the argument that I was making when I was talking about private causes of action. I mean, I don't have to rely on the IMTCA for the general waiver of sovereign immunity in filing an assault claim. So why on earth would the exceptions apply? And then you get to the constitutional question: is what on earth did the Iowa founders mean when they included Article 1, Section 8 in the Iowa Constitution in 1857? And I'd go back to Justice McDonald's concurrence in Lynette, where he pointed out that they must have meant what they recognized at that time, that assault and battery claims against local officers were allowed. And the legislature cannot, Justice Mansfield, they cannot negate the Iowa Constitution, which is what they would do in effect if they're allowed to say, any emergency, we can assault somebody without justification. There's no such thing as an assault without an emergency.
What portion of the Constitution talks about allowing damages for this particular case?
On the supremacy clause that says that the Iowa Constitution is the supreme law of the land. The legislature cannot pass a law that negates Article 1, Section 8.
Portions of the Iowa Constitution that provide for damages in other circumstances?
For the circumstances of damages? I don't know the answer to that question, Justice May. I apologize.
That kind of situation.
Some provisions about taking the land. I don't know about civil lawsuits, but I do know that we need to hold people accountable. There's no such thing as a right without a remedy, and that the legislature cannot negate constitutional protections. I don't think you need to get to that point here, because the common sense just dictates that if I'm not relying on the general waiver of sovereign immunity in the Municipal Tort Claims Act, the exceptions to that general waiver are irrelevant to my claim.
Questions, your time's up, and you get a chance to come back. We'll have Ms. Juehring.
May it please the court, counsel. The district court correctly held that Scott County and Deputy Hill were entitled to the emergency response immunity found in Iowa Code Section 670.41K. Mr. Mitchell created an emergency situation by physically resisting a lawful arrest and then only escalated the emergency from there by jumping into his vehicle, rapidly driving it back and forth and back again, and ignoring all commands to stop. All the while, Deputy Hill was partially inside and partially outside of this vehicle, trying to stop Mr. Mitchell and trying to keep himself from being struck or run over by the vehicle.
So the emergency response provides immunity unless there's a statute that provides extent liability may be imposed. Are there any statutes that address emergency response and use of force?
No, Your Honor, but I don't even think the court needs to get to that question because Ms. Thorington hasn't preserved error on that issue. Below, Ms. Thorington never argued that the second sentence in 670.41 that states that the immunities may not apply if there's an express statute imposing liability exist. That argument was never raised before the district court.
The only arguments related to 8048 were whether or not there was a private cause of action. Is that your argument? Or how was 8048 addressed below?
How it was addressed was after remand of this first appeal, Ms. Thorington filed a second amended petition, which she brought claims for assault and battery, and she also brought a private cause of action under Section 804.8 in Chapter 704. The defendants, Scott County and Deputy Hill, moved for summary judgment on those claims, arguing there was no private cause of action under those statutes. Importantly, in Ms. Thorington's resistance, she didn't even address that argument whatsoever. Made no argument in the resistance that that these were private, that there were a private cause of action in these statutes, or that these statutes fell within the second sentence of 670.41.
In terms of error preservation, the argument Mr. O'Brien is making now that 804.8 qualifies the emergency response exception, that argument was not made below.
Was not, and it was not decided by the district court. The district court never, in its opinion, examined that second sentence in 670.41 and made the determination of whether these statutes fell within that second sentence such that the emergency response immunity would not apply.
The 804.8 preservation issue, are there any limitations on what an officer can do once the emergency response box is checked? So here, the allegation is that there's an intentional tort. And I'm just kind of wondering, you know, you can think of situations where, let's say the police officer here not only fired at Mr. Mitchell, but fired at the passenger also and said, you know, I want to make sure that neither of you leave. Would her claim for assault perhaps be limited by 670.41K?
Your Honor, there is limitations to the emergency response immunity. First, it doesn't, as is premised in your question, it doesn't necessarily apply to all assault and battery claims. Second, the immunity doesn't apply if the officer acts outside of the scope of his employment or duties. And I think third, and probably perhaps most important, is that the immunity does not immunize an officer from punitive damages if the officer acts with malice or reckless behavior.
Get the outside of the officer's duties. For the assault claims, once that emergency box is checked, what assault claims wouldn't apply if it's within the officer's course of duty?
I'm not quite sure, Your Honor, and unfortunately that's not the case before the court here. But I think what is...
Third exception you mentioned where it's with malice, does that mean that there needs to be a trial to make that determination in this case?
No, Your Honor, because that third exception only applies when there's a punitive damages claims and request. And Ms. Thorington here withdrew her punitive damages claim. So whether or not Deputy Hill acted with malice...
Dismissal? I thought there was a punitive damages claim in the case. Is that not right?
Was, but after the district court granted summary judgment on the emergency response immunity, Ms. Thorington withdrew her punitive damages request, and then this appeal occurred. Yes, Your Honor. So whether or not Deputy Hill acted with malice or recklessness is not at issue before this court today.
Circumstances where the emergency response immunity could be unconstitutional as applied to a particular case?
No, Your Honor, because I believe that the legislature has the authority to enact this emergency response immunity to immunize officers who are placed in these tense situations where they have to make snap judgment.
I think the Supreme Court says, and we've said, excessive force claims are search and seizure claims. An excessive force claim is an unconstitutional seizure, right? Said that, we have said that. So if a plaintiff, by statute, cannot sue on that claim, doesn't that deny him that right?
Your Honor, I think the holding in Socorro is that the legislature is free to enact immunities that limit monetary damages action.
Article 1, Section 1 claim. I mean, here we have a specific provision. The Constitution says that there shall be no unreasonable searches and seizures. I think you agree killing somebody is an unreasonable seizure. It's a constitutional violation. And you're saying the legislature says that you can have unreasonable searches and seizures.
Your Honor, again, I think the holding of the majority in Socorro applies here, where the legislature is free to enact immunities that may limit a litigant's ability to recover monetary damages on state law claims. That certainly doesn't limit a litigant's ability to file a 1983 action.
Same theory. It's a federal cause of action for a violation of a constitutional right. Why should we as a state be dependent to enforce our own Constitution under a federal cause of action? You act like the court and our government has no agency in kind of regulating police conduct. I don't understand why that makes sense.
I would also go back to the point here that the immunity at issue does not immunize all assault and battery claims. It immunizes assault and battery claims in very specific situations where our officers are placed in emergency situations and required to make snap judgments.
And would you also agree with me that in 1871, Congress enacted 42 U.S.C. 1983. It's been the law of the land ever since, enacted as legislation, allowing citizens whose federal constitutional rights have been denied under color of state law to file a suit. The legislature here in Iowa has not enacted a comparable statute. Isn't that true?
Your Honor, and Ms. Thorington had the opportunity, actually following remand of this case the first time, to file a 1983 action.
Brings us back to the IMTCA, where it does allow her to bring in assault and battery claim. it's subject to the emergency response defense or immunity. But that takes me back to the question I asked you before, and we got off on error preservation. Is there a statute that limits what an officer can do with respect to using force in an emergency response?
Your Honor, Section 804.8, as this court has held as recently as its 2023 decision, White v. Harkwriter, it's an affirmative defense that an officer may plead and prove. Iowa Code Chapter 704 also contains a number of affirmative defenses that officers could plead and prove in defense of certain causes of action. Those statutes do not impose liability on an officer or create any sort of cause of action for plaintiffs to bring.
Our situation, we heard a case last month involving an officer who violated the rules of the road. And so do we need to be consistent with the way we treat that case and the way we treat this case with respect to 321, 231, providing what could be a defense? If that's a defense, and this is a defense, but if that recognizes liability, then this recognizes liability.
I'm familiar with that case in the statute 321, 231. I would say that the distinction here is that there's nothing in the language of the statutes cited by Ms. Thorington that imposes liability on officers when they use force.
13 involving justification play in with respect to officers.
4.13 merely says officers are immune from civil liability if for damages incurred if the reasonable force standards laid out in Code Chapter 704 apply. It doesn't.
13 says the person who is justified is immune. So if an officer goes beyond what they're justified in using force, then doesn't that immunity go away?
Yes, the immunity under the Iowa Code Chapter 704, the immunity code statutes under Chapter 704 may very well go away. But there's nothing in those statutes that say these are the only immunities available to law enforcement officers who use force in responding to a suspect who's resisting arrest.
As two different types of immunities and as a defense, as opposed to recognizing under that first section, or the first sentence of 604.1, a statute that addresses liability with respect to certain circumstances.
I think that's correct, Your Honor. I think what these statutes do is that they create different defenses available to anyone who may use force in response to an aggressor, including law enforcement officers. And the legislature knows how to craft immunities and could have included in those immunities that these are the only immunities in 804.8 and 704 that can be applied, and they didn't. They can be relied upon by law enforcement.
That an officer who shoots someone in an emergency, regardless of whether or not they follow 804.8, is immune under the emergency response statute.
Your Honor, they're immune from monetary damage state law claims if the requirements of the emergency response immunity are proven.
Kind of gets back to, so what are those requirements other than there's an emergency? I mean, I'll give you the, Mr. Mitchell is the one that maybe created the emergency, and so there's an emergency here. 804.8 does not play in, then as soon as there's an emergency, the officer can essentially do whatever they want because there's an emergency.
No, Your Honor, I don't think that's quite right. Their officer's reaction has to be in response to that emergency.
It's in response, but that's what I'm trying to get at. Does 804.8, if that doesn't play a role, then what cabins what an officer can do in response to the emergency?
I think the officer is limited by their actions could still be subject to a punitive damages claim even if the emergency response immunity applies. And I think it's important to consider the facts of this case here as well. In this case, Officer Hill was placed in a situation.
What is a punitive damages claim?
I guess the term claim may not be the most accurate to use, but punitive damages, if
To bring a tort claim, so you you'd have to bring an assault claim or a battery claim with a request for punitive damages. We've already said that there are no standalone punitive damage claims.
Yes, Your Honor, I think in the situation where there was a punitive damages request and a court found that the emergency response immunity applied, the claim would then proceed to trial, perhaps, and if there was a certain jury findings, then punitive damages could be.
Even if there's an emergency response immunity and if it applied, if there's a request for punitive damages, you'd still have to have an assault and battery trial before you could even get to the question of punitive damages.
Your Honor, that may be the case, but that's not the case here because there is no punitive damages request at issue in this case.
At the time the motion was denied, or the motion was granted, it was only dismissed afterward to make the judgment final.
Yes, that's correct, Your Honor, that the punitive damages request was withdrawn or waived at that point in time. But it has been waived or withdrawn, and it's no longer an issue in this case. Unless,
At the time that the motion was being considered, there was a punitive damages claim. The defense was, we have an emergency response immunity. Why didn't the existence of the punitive damages claim at that time mean that you still needed to go to trial?
I think this case was still headed to trial prior to the plaintiff, Ms. Patty Thorington, withdrawing her punitive damages request. But once that...
And battery claims were knocked out because of the immunity, of the emergency response immunity, right? Okay. But then the punitive damages would just gone as, I guess that begs the question then, what claim is a punitive damages claim or remedy attached to?
I see my time has expired. May I answer that question? Okay. I don't think that the summary judgment being granted and then Ms. Thorington withdrawing her punitive damage claim happened fairly close in time. And I don't think we had enough time to really flush out what was going to happen at trial if the punitive damages request wasn't withdrawn. But it was, and it's no longer at issue in this case.
I just want to explore this one issue a little bit further on the immunity question. So could the legislature pass a statute that said we are going to authorize the issuance of general warrants and whoever holds a warrant is immune from suit?
If that ran afoul of the Constitution, then I don't think that the legislature could enact that proscriptive statute.
Do you think it does?
I'm not sure I understand your question, Justice McDonald.
It said we're going to authorize the issuance of general warrants and whoever holds a general warrant shall be immune from suit. Is that in violation of Article 1, Section 8?
Your Honor, it may very well be, but that's not the issue before the court today.
I mean, it seems like the granting of if you just say, hey, people who don't have general warrants are also immune from suit for things that violate the Constitution directly, that seems to be in a more egregious violation to me than authorizing general warrants. Now you're just saying people without warrants also get to violate the Constitution. I don't know why that's any more constitutional because you eliminate the general warrant requirement.
I think that the immunity and the undisputed facts on the record before the court now are far more narrow than in that situation. And here we have a specific emergency response immunity that the legislature made the policy decision to enact, and the actions of Deputy Hill squarely fall within the scope of that immunity. So with that, I would thank the court for its time and respectfully request that it affirm the district court's decision.
Brian.
Thank you, Chief Justice. Just a couple of things. One, I think we did preserve the claim. We had discussions about this at the district court. The district court said that we argued that 704.13 and 804.8 created a private cause of action, and he denied that request, but we also discussed that as part of our other arguments that were made before the district court, that sudden emergency response immunity did not apply to this case for those reasons. These all drop together.
Things aren't exactly tied, though. As I read the district court's ruling, there's a section, that deals with your emergency response, and then there's a section that deals with your 808 and 704 claims. I don't see any ruling where the district court specifically says that 804.8 creates a carve-out to 670.41K. So is it really preserved?
So, because we did argue that, even though I agree the district court didn't specifically address it, but it was part and parcel. I mean, it's hard to separate these things.
The district court didn't rule on it, then did you need to file, a post-hearing motion to get a ruling on it? Because typically we would only take it up if it's been ruled on.
It was necessary because the district court denied our argument that emergency response immunity didn't apply here for any number of arguments, including that one, were not, and the arguments that I already made here. So I think you're splitting hairs to argue that when we said he violated 8048 in the way that he used deadly force in this case, that didn't apply.
Respectfully, I don't think that's splitting hairs. I mean, there's a difference between, you clearly did argue private cause of action, that you had an independent right of action. That's one thing. But the other question is, kind of what we were talking about in the Mormon case when we were all together last month, and the issue there was, is there an exception to the emergency response immunity based on 804.8? In other words, and that's not a private right of action, that's a cause of action for assault and battery where the 804.8 negates the emergency response immunity. Did you argue that below?
I believe that we did, because we were arguing all of these as a basis for concluding that emergency response immunity didn't apply, that it was unconstitutional because it violated the Supremacy Clause, that the statute didn't apply to us for a number of reasons, because first of all, because we aren't seeking the protection of the waiver of sovereign immunity contained in that statute. But we made these arguments. I don't know if it was as explicit, but that's why I refer to it, I think, as somewhat as splitting hairs. In the Mormon case, it's easier because 321-231 had already been adjudicated as a specific statute on the subject that could make officers subject to civil liability. At least the Court of Appeals had held that way, and then this court refused further review.
Can I ask you about these punitive damage issues? Educate me a little bit on, have you had one where you've actually gone to trial on just a punitive damage claim as the district court sort of left at the end, or?
No, not against a law enforcement officer. I mean, we cannot justify all we go through. Every case goes up on appeal twice sometimes, as we now know. I can't do that based upon a punitive damage claim against a local police officer's personal finances where the damages are minimal. In the Mormon case, the gentleman officer who was involved there had some fairly substantial assets, and the jury awarded $10,000. It just doesn't warrant the effort, which is where we came to the conclusion here that we wanted a clean, you had it exactly right, Justice McDonald, we just wanted a clean argument to present to you folks. Otherwise, and it was still open question, if we went to trial, did I have to still approve assault, battery, bring all my experts in, and then get to the punitive damage claim? I mean, how is this going to work? It was a nightmare. And I had some discussion with counsel about this, and we all thought, let's just get a clean fact pattern up to the Supreme Court and let them decide.
And then is whatever punitive damage claim you had, whatever effect that would have had on going to trial, that's gone because of the voluntary dismissal at this point.
Dismissed it after the other case was dismissed because we knew we'd have to try the whole thing in order to get to that point, and it just didn't justify that. And I have to say that this officer's conduct, remember the fact here is that he went into a black box, as he described it, and wasn't processing new information. He couldn't tell you what was going on during that time period. I don't think he's a bad actor, but he overreacted to bad information that he had previously, and he stood up free and clear of harm's way and fired 3 shots and killed Bobby Mitchell. And I do want to talk about the Barnes versus Felix case.
Ron, you can briefly address that.
It is Imagine in this day and age, getting all 9 justices of the U.S. Supreme Court to agree that officer-created jeopardy should be assessed where an officer jumps onto a running board of a car that's trying to escape and then fires shots to protect himself because he's on the running board. Very similar fact pattern here. Deputy Hill's in trouble because he refuses to let go of Bobby Mitchell's hand. When he did let go, he stood up free and clear of the car, fired 3 shots and killed him. And that is at least a fact issue for an assault without justification.
1983 case, I'll tell you, my former boss wrote the Fifth Circuit dissent in that case that was essentially adopted by the U.S. Supreme Court. But that's a 1983 case, right?
Judge Higginbotham, I hope you channel him as we're assessing this one. Thank you, Justice Mansfield. And I do apologize if I got a little argumentative. I didn't mean it that way. It's just the give and take. Thank you.
Further questions by the court? Case of Thorington versus Scott County is hereby submitted.